power. And so a little bit about why we wanted to actually focus on this topic is that we talk so much about why you actually need a trademark, and then our clients get trademarks and then they don't know what to do next. And so today I really want to focus on what do you do in order to enforce your trademark rights while you're waiting for your trademarks to register, before you've started the trademark process, and then after your trademark actually registers. And so that is why we are focusing on mastering trademark enforcement. All right, let's get started. So today we're going to be talking about, number one, a little bit about the Curry Law Firm. Number two, trademark basics, so that you can understand just the basics of what a trademark is actually supposed to do. What are common law rights? What are federal trademark rights? How do you enforce these rights? And how can we help you here at the Curry Law Firm? So the Curry Law Firm was founded by real estate professional, serial entrepreneur, and attorney Eleanor Curry. Attorney Curry has 10 years of law practice experience and even more experience in real estate. Practice areas that we focus on are going to be trademarks and copyrights, of course, estate planning. This includes wills, trusts, power of attorneys, and more, real estate law, and business law. All right, so a little bit about trademarks before we hop into the common law rights. So, trademarks are essentially used to protect your business brand. Your business brand could include your business name, your logo, your slogan, maybe even the design of your products. But it's what people see or hear and directly relate to your business and the service or products that you offer. For example, when we think of the phrase a Coke bottle shape, we connect that idea in our mind to Coca-Cola products. So that would be Coke, Dr. Pepper, Sprite, things like that. They all come in the same bottle shape. When we think of just do it, our mind would automatically go to Nike. And so that's what we mean by what people see or what people hear, and how they automatically connect those brand items to your business and the services or products that you offer. And so it's really crucial as a business owner to make sure that you are protecting these items with a trademark. Why is that? Could you imagine building up a following and building up a consumer base? Maybe, people who enjoy your products or services, or people who are following your page through social media, and someone else comes along with a very similar name, doing something very similar to what you're doing, and people are starting to gravitate or attract to them, thinking that they're actually coming to you for the services or products you offer. This could significantly decrease the amount in profits that your business or you could actually bring in, because this other person is using your brand and capitalizing off of it. So a trademark is meant to prevent this. It is meant to protect your brand items, once again, such as your name, your business name, your logo, your slogan, your social media handle, things that you're using to advertise or market services or products, or even yourself, right? Because sometimes we're our own walking brand, and prevent other people from capitalizing off of that. So, a little bit about common law trademark rights. Raise your hand in the chat if you've ever heard of common law trademark rights. All right. So, a common law trademark rights are obtained as soon as you begin openly advertising or publicizing services or products with your brand name, logo, slogan, and more. An example, you start a business social media page with your brand showcase, telling people how the services or products that you offer can help them, right? You've openly started using your brand in order to offer services or products. You immediately have common law rights. What type of protection do they offer? So common law trademark rights are useful when you're proving that you have been using a particular brand name, logo, or slogan before someone else began using it. And it can also be helpful when you're actually filing your trademark application and you're trying to figure out when did you actually start to use this name, right? And so that's really what common law rights are used for. There's no strong protection that comes with them. anytime that you're going to have to try to enforce your common law trademark rights, I'm going to tell you now, it's probably because it's too late, right? You should have already trademarked. You're having to go through some litigation process, or maybe you're having to send someone cease and desist letters because they're infringing on your rights. It's not upfront. It's later down the line because you didn't properly take the steps to protect your brand items with a registered trademark. So, what are federal trademark rights? Federal trademark rights are obtained when you register a trademark with the United States Patent and Trademark Office. Notice I specifically said register a trademark. Simply filing a trademark application with the United States Patent and Trademark Office does not grant you federal trademark rights. You do not obtain those until your trademark actually registers. That means you've completed the entire application process and you have a registration number with the United States Patent and Trademark Office. They grant the trademark holder protection rights in all 50 states and are recognized by other countries. So even if I am operating my business in the state of Oregon and someone in the state of North Carolina is using the exact same name to offer very similar services or products, if I have a registered trademark with the United States Patent and Trademark Office, I can tell them, hey, you can't use that because I actually have trademark ownership rights of that brand item and you're infringing on my rights. So what type of protection do they offer? The most important is in all bold letters here, they prevent anyone in the US from using the same or similar brand items, such as your name, logo, or slogan, for the same or similar products or services you offer. They allow you to obtain priority sellers access with Amazon. So Amazon now has a what's called a brand registry for people who are going to be sellers on Amazon, and they'll give you priority for your name if you can prove that you have a pending trademark application or a registered trademark. They allow you to shut down social media pages and domain names that are infringing on your trademark rights. So places like Instagram, Facebook, TikTok, they have legal departments that focus on intellectual property rights, which a trademark is a form of intellectual property. And if you can prove to their legal office that you have trademark rights to a specific name or logo, and someone on one of their social media platforms is using your brand item in a way that infringes on your rights, you can submit a trademark infringement report to them and show screenshots of how this individual is utilizing your trademark and show screenshots of your registered trademark with the United States Patent and Trademark Office. And they can actually shut down those pages or remove the items that would be considered trademark infringement. And you probably may have come into some interaction with this on the copyright side. Places like Facebook or Instagram, they stopped allowing like business pages to utilize mainstream songs or songs that are protected by copyrights for their business page because you're using their song or their video or imagery in order to gain monetary income. And so copyrights are different, but that's kind of just one example of how their legal departments actually do go through social media to try to stop anything that could infringe on someone else's rights. So how do you enforce trademark rights? Well, there's a few ways to actually enforce them. And so let's start with before you register your trademark, right? You've just thought about this name. You've maybe started the social media page. You don't really have too many posts. You're just trying to really put it out there. Maybe you're inviting close friends and family to come take a look at it. In that instance, you can start to use the TM symbol. And you guys have all probably seen this next to things that are actually products you buy, or sometimes people on social media are just putting these next to their name or sayings that they love to say. So before you register your trademark, you can begin using the trademark symbol because it will put the public on notice that you intend to trademark an item or you're in the process of trademarking an item. So that's great because then people may back off and say, oh, okay, well, someone actually is intending to trademark. Maybe I should try to find a different name or a logo or slogan for my business. Now, the con to this is the same as the pro. It puts the public on notice that you intend to trademark an item. And this can give competitors a heads up. This can actually tell them, hey, I actually am going to start the trademark process now while they're waiting to trademark. And I'm going to trademark this name or this slogan before they get a chance to. So If you begin using the TM symbol, I usually tell my clients to start using it once we submit the trademark application to the USPTO. And then if we find that a lot of pages or different businesses are using the exact same name or a very similar name and have been using it for a longer period of time than my client, I honestly would sometimes tell them, hey, maybe we should hold off on letting people know that you're submitting a trademark application. So don't use the TM symbol yet, because we don't want to put people on notice that you're trying to start the trademark process and then they try to oppose your application down the line. So use the TM symbol with discretion. It can be helpful in proving that you've been using a specific name or logo for a specific amount of time, but it can also be harmful in a sense that is putting your competitors on notice that you are seeking trademark protection over something and they could start the process before you. Um, After you register your trademark, how do you enforce your rights? Well, you can actually start to use that R symbol, right? So you see it here on the screen, that R inside that circle, that means you have a registered trademark. And so both the TM symbol and the R symbol refer to the trademark process, but the difference is that the R means you actually have a registered trademark versus the TM means that you intend to submit a trademark application or you're in the process of having your trademark application reviewed, but it hasn't quite been registered at this time. The registration mark is helpful because you do have an active duty to enforce your rights against infringers. And so this can help to put the public on notice that you actually do have a registered trademark and they should stop any use that could infringe on your rights. Another thing you can do to enforce your trademark rights is to do routine searches. The same way that you would research a new restaurant to look at or different foods to try for the holidays, you want to do routine searches in order to see are other business owners or just people in general utilizing the name or the slogan that you have trademarked for the similar or same products or services that you offer. And so sometimes my clients are like, hey, I was just doing some searches through Google and I came across a website that is using my business name to sell the exact same products I offer. And they just found this through doing routine searches. Or another thing, doing routine searches through social media, especially if that's a way that you heavily publicize the services or products that you offer. And another page is using the same or a very similar name, and your consumers are getting confused and saying, oh, I actually purchased products from that page because I thought it was yours. I thought it was just a related business. You want to do these routine searches so that you can kind of seek out the infringers that are out there, because they're not going to come knocking on your door telling you, hey, I'm using your brand in an infringing manner. No, you're going to need to go and find them. So routine searches can help with that. And another thing you can do to enforce your trademark rights is to take legal action. If you reach out to someone to tell them to stop using your trademark and they don't stop, then hire an attorney. So how can we help? So we can help, number one, by helping you to register your trademark. So filing your trademark with the United States Patent and Trademark Office. This is a service that we offer. It includes filing the application, and before that, doing research to see are there any pending or registered trademarks that would prevent you from being able to successfully register this mark. And then answering any questions that the United States Patent and Trademark Office may have about your trademark, and then kind of following it through until the registration of your trademark has been completed, or the United States Patent and Trademark Office makes a final decision to either deny your application or prevent it from moving forward in some way. We can also send cease and desist letters. So, on the previous slide, I was saying that if you reach out to someone and they don't stop using your mark, then you can hire an attorney to have them send what's called a cease and desist letter. And this is a letter that's sent to a party infringing on your rights, notifying them of your trademark rights and demanding that they cease use of the trademark. You can send a cease and desist letter without having a registered trademark. You could be claiming common law rights. You can. The only thing I will warn you against is that if you send a cease and desist letter claiming, common law rights, this person's probably going to look up your name or your use, whatever you're claiming rights to in the trademark system. And if they don't see an application, they may go ahead and file it. So you could send a cease and desist letter, claiming common law rights, but I would do this once you either have a pending trademark application and their use has been less time than your use has been. So that means you have priority, you've been using it longer, or you have a registered trademark already and they're using your mark in a way that's infringing on your rights. So those would be the two times that I would suggest the cease and desist letter usage. Trademark litigation. This is something we don't recommend because it's very costly, it's lengthy. We usually want to try to send a cease and desist letter first instead of just filing suit. Now, if they still don't stop using your mark when you do send the cease and desist letter, that's when you would look to filing the lawsuit. But it can be a very lengthy process and the cost starts to add up very, very quickly. But it's something that we're happy to help you with. And then licensing agreement. So we've talked about the fact that trademarks can actually provide assets to your business, and licensing agreement is one way that they can. So suppose somebody is infringing on your usage of your trademark, and they say, hey, we really want to use this. What if we agree to only use it in the state of Missouri? We only use it in the state of Missouri. Would you consider giving us permission to use it? And you may say, okay, I'll give you permission to use it just in the state of Missouri for these specific services, and you can charge them for that use. And so the way that you would provide this permission is with what's called a licensing agreement. You're providing them a license in a specified manner to be able to use your trademark, for monetary gain. And so we can prepare this contract for you to give to others. And then it's something that, we can prepare once and you can kind of keep in your keeping, and maybe just change the name of who's going to use it and the rate that you're going to charge them. It's not anything that we have to continue to draft each time you use it. Or you can say, hey, you know what? Because the way that these people are using my trademark could definitely vary, then I need you to draft them every single time. Then we can help with that as well. But those are some ways that we can help with enforcing your trademark rights. And now I'll go ahead and open it up for Q&A, just so that you guys can have the opportunity to ask some questions about this topic, and anything that you may want to know about the trademark process. If you are wanting to speak with us on an individual level rather than in the chat, you can always call the office to book a free consultation at 713-574-2070, or send an email to our head attorney at ecurry@theclfirm.com. You can send her an email and she'll be happy to set you up with a consultation, either with herself or myself. Or visit the website and you can get a consultation set up there. But I'll go ahead and allow you all time to ask questions in the chat.